Okay, I think everybody's mic'd up, and I want to welcome you all this morning. Thank you for coming. My name is Tony Morrow, and I am on the steering committee of the Reporters Committee for Freedom of the Press, which is co-sponsoring this. And I want to thank NYU also for sponsoring this event. I've also covered the Supreme Court for 34 years and have been immersed in these issues for pretty much all of that time. This is the second discussion we've had on this subject of transparency at the Supreme Court. The last one was a few months ago. The theme then and now really is that transparency in the case of the Supreme Court is about way more than just allowing cameras in the court. So of course that is very much on our wish list. We'll see these other issues related to transparency develop even more this morning than at the last event. We have a terrific panel to discuss these issues, led by Dahlia Lithwick of Slate. It's my great pleasure to introduce her. She also is on the steering committee of the Reporters Committee for Freedom of the Press, and another panelist, Sonia West, used to be an intern at the Reporters Committee. Dahlia has covered the court since before the turn of the century, and when she arrived on the beat, and ever since, she's been a breath of fresh air, bringing tremendous insight as well as a touch of humor to covering the Supreme Court beat. When she writes about a Supreme Court argument, you almost don't need cameras. Emphasis on almost, because her writing is so vivid. Before I turn it over to Dahlia, I want to mention that if you'd really like to give the Supreme Court a piece of your mind on these issues, there is the SCOTUS booth of truth upstairs where you can tape a brief video with your views on these issues. Now I'll turn it over to Dahlia. Thank you.
So thank you, Tony, and I want to redouble Tony's thanks to the various sponsors and to NYU for this absolutely gorgeous venue. You all probably know that last fall, for the first time in history, some advocacy groups snuck camera into oral argument, and for the first time ever, we got to see live video of oral argument, which actually looked more like a sighting of the Loch Ness Monster. It was awfully blurry and confused. But, America went kind of crazy, and people were interested in it, reminded, especially those of us who go back and forth to the court and who get to be in those arguments, the extent to which, the branch that is meant to be the most transparent and open and, everything that you need to know about the court's workings is contained in the four corners of the opinion, is actually completely unknown and unknowable to 99.9% of the American public who were glimpsing for the first time blurry judicial shoulders and getting very excited about it. So we're here to talk about transparency. Not just cameras, but all the aspects of transparency. But I want to just open by saying that transparency means not just that we can't see the workings of oral argument, but it means we also can't hear the workings of oral argument until the court releases audio on Fridays. We can't readily access their website. When we, on the day the healthcare cases came down, tried to access their website, it crashed. The best source of getting information about the court is not, in fact, the court's website. It's other websites. We don't know the justices' speaking schedules. We don't get copies of their speeches. It's very difficult to get their financial disclosures. Don't get me started on their papers. And so this branch that's supposed to be open and one of three co-equal transparent branches of government is awfully hard to get into. And so that's what we're here to do today. And we thought that in lieu of me reeling off introductions of our panelists, who are amazing, each in their own right, I'm going to ask each of them to just introduce themselves to you and tell you for half a minute who they are, why they have skin in this game, and then I want them to answer a question that is completely open-ended, because that's the kind of hipsters we are. And the question is going to be, what does transparency at the Supreme Court mean to you? So we're going to start right here with Willie and go down the line. And so just 10 seconds on who you are and why this is an issue that is important. And then if you would sort of develop an idea about what transparency means to you.
Sure. Well, thank you, Dahlia, very much. It's a real pleasure to be here. I am Willie J. I'm a partner at the law firm Goodwin Procter here in D.C. And why am I here? I'm here because I am a lawyer who briefs and argues cases before the Supreme Court. I used to work for the Justice Department in the Solicitor General's office, and now I'm in private practice, and much of my work in private practice as well is before the Supreme Court. So what does transparency mean to me? To me, as a lawyer and as an advocate, it's not about the cameras, it's not about the papers, it's not about the speeches, and it certainly isn't about the financial disclosures. It's about the decision of cases, which after all is the justice's number one job, to decide cases. When they decide cases, what do they decide, and what do they decide them based on? Those are kind of the transparency things that get me up in the morning, because the courts will often say, we're a transparent branch because everything's public. The briefs are public. They're on a website, not the court's website. The oral argument is public. It's transcribed, easily perusable on the court's website, and so on. But does the court limit itself to what's in the briefs or not? And I think one striking example of that is sort of buried in Justice Kennedy's juvenile life without parole opinion from a couple of years ago, where he was developing some statistics about how many young offenders were incarcerated for a term of life without parole. And you see in that opinion very unusual citations, including letter to Supreme Court Library from Federal Bureau of Prisons, letter to Supreme Court Library from, I think, District of Columbia Department of Corrections. Basically, the justices had asked other parts of the federal and municipal DC government to do some research for them and provide that information secretly, not copied to the parties. And I'm not revealing any inside information because I don't have any, but the Solicitor General didn't participate in that case. And it may well have been a complete surprise to the Attorney General, the Solicitor General, and the people to whom the Director of the Bureau of Prisons reports that the Bureau of Prisons was opining or even providing factual information on this fairly complicated, nuanced issue. I think it was a surprise to the advocates as well. So when you're standing in the court, you speak your piece, you sit down, and the Chief Justice says the case is submitted. The briefing is all done. The oral argument is all done. But then the researching begins. And so the transparency concern that I have is that the justices often view that as the beginning and not the end of the fact and law and science gathering process. Justice Breyer, I think, is also fond of citing lots of social science and other secondary literature in his opinions, in most cases, none of which is cited by the parties, not cited by amici. It's his own research. That's how he decides cases. He finds it useful. But how do you respond to those citations, and how do you convince him not to rely on them because you haven't seen them until they appear in his opinion?
Clay.
Hi, I'm Clay Johnson. I'm the CEO of a company called the Department of Better Technology. I'm a former Presidential Innovation Fellow. I used to be the director of Sunlight Labs at the Sunlight Foundation, and before that I was the founder of a company called Blue State Digital. We made BarackObama.com in 2008 and a bunch of other things. And I guess I'm here to represent the sort of technical aspect of this, as you can tell by my lack of tie. What does transparency mean to me in terms of the Supreme Court? I think it means three things in this descending order of priority. The first thing that it means to me is education. There are no other fields in the world that I can think of where the players at the top of their game are obfuscated from public view. Imagine, if you will, if we took every beautiful skyscraper in the world and wrapped it in a cardboard box before you could see it, or that the scores to the Super Bowl were the only thing that you saw from the big game. And this has an adverse effect, I think, on people who aspire to these jobs or to aspire in the legal profession, not to be able to watch people that are at the top of their game deliberate before the court and argue before the court. I think that that's a remarkable loss. The second thing is history. Transparency means history to me. We are doing a great disservice to the majesty and dignity of the courts by making it so that decisions like Bush v. Gore or Citizens United are captured in low-resolution audio files, and that's it. And moreover, because of various technical things, oftentimes web pages are cited in arguments all of the time. But someone did a study more recently that said that about 30% or so of all of the links that are cited in these arguments are now gone. So we're not taking that sort of technical step of archiving the context of these decisions at all. And as we further rely on technology and especially the web in order to do that, this level of context being removed seems to be a great disservice to our children and to the people that are going to come after us. And finally, it's about accountability. And I don't find that argument to be the biggest and most important one, although it is important. I just find that my work both inside and outside of the federal government, going to anyone and saying, hey, I would like to place a camera behind you so that I can watch and scrutinize everything that you do in real time tends to be a tough sell. And so I tend to lead with more substantial arguments like, this does not reflect on the dignity of your job. And so I think those are the three things that matter the most to me around transparency and why I care about this issue.
Eric.
Good morning. I want to thank Gabe for inviting me here and Tony and Dahlia for hosting it. I'm really flattered to be here. My skin in this game is pretty serious. I teach constitutional law at Georgia State in Atlanta. It's very ironic to me that the Supreme Court might be the least transparent court in the United States because at best, I'm with Judge Posner that it is a political court. I, in fact, don't think it's a court at all. So to the extent there are transparency issues to begin with judges, I don't think the Supreme Court really counts as a court. And I'll give you just a great example of that. Every year, thousands and thousands and thousands of people send cert petitions to the Supreme Court. Lawyers spend hundreds of hours working, fees are paid, the parties are incredibly invested in this. And maybe the most important decision the justices make is which cases to hear. Because if they don't hear a case, then whatever happened at the appellate level is the final say, and we're done. And we don't even know which justices voted to grant cert in a particular case. This is an incredibly important public vote on a matter of public concern, and there is simply no reason why we shouldn't know this, and it's relevant, truthful information about a public body. Now, they may argue that too much will be read into who decides to grant cert and all of that. But the bottom line is, I was litigating Supreme Court cases in the 1980s with some of the leading litigators at the time. And at the trial court level, we had a church-state case. And the entire effort was to make the record such that Justice O'Connor would be pleased. And this was 5 years before O'Connor would even see the case. There's so much speculation going on anyway. If we know that 4 moderates vote to grant cert in an abortion case, we have some idea where Justice Kennedy might stand, or at least where they think Justice Kennedy may stand. That might be wrong, it may be right, but who votes should be a matter of public record. And which leads me to my overall point. With the president, with the Congress, with state legislatures, there is a presumption of transparency, and then there has to be a good reason for secrecy. And if there's a good reason for secrecy, the presumption can be overcome. When it comes to the Supreme Court of the United States, there is this huge presumption of secrecy, and only if that is overcome do we get transparency. And that, to me, doesn't make any sense at all. So I've now run this by a lot of Supreme Court litigators and law professors, and no one has yet given me a good reason why we can't find out who voted to grant cert in a particular case. And if we don't have a good reason for it, the public should know relevant, truthful information.
Bruce.
I'm Bruce Brown, and I'm Executive Director of the Reporters Committee for Freedom of the Press, and I'm here because the committee was underrepresented today and felt we had to balance the panel out. And for the Reporters Committee, which represents the interests of journalists in covering an institution like the Supreme Court, obviously we care deeply about the immediate access to see and hear what goes on in the building. And we care about it not just for us, but for, of course, the public at large. And there's a great moment described in the book, The Fourth Estate and the Constitution, about the oral argument in Richmond newspapers, which came along at a time when the press had been losing access cases when it had been arguing for some kind of special privilege that it had. And Lawrence Tribe, who argued the case for the newspaper petitioners, is asked, is this just another example of the press coming in and asking for some kind of special protection for its own interests? And Tribe responds and says, no, the access we're seeking is the access that belongs to the, excuse me, the general public. And that was the Agincourt for access law. That was the moment that tipped the scales, and the court in Richmond newspapers then grants this historic decision recognizing the right of access, again, not just for the press, but for the general public. And when we at the Reporters Committee think about access, we're thinking not just in the short term, can we get reporters into the court to cover the hum of what happens in a particular news cycle in the building, but also the long term. Dahlia mentioned papers and Supreme Court papers. And one issue that we're also very interested in is trying to really force the court away from this ad hoc system of each justice deciding on his or her own when and how and under what circumstances to make papers available, and to move instead to something more regularized like what you have in the presidential system now, which was put in place by legislation in 1978 to deem those papers property belonging to the public and not subject to the particular decision-making of any particular justice when he or she leaves the court. And when you ask what access means to me, I did want to respond in terms of extreme particularity. I wrote some statistics down. My wife's grandfather was a lifelong friend of Justice Douglas, and we discovered when he passed away that he had a number of letters from Douglas, and we were kind of trophy hunting, going through the papers and seeing this stuff. And so I looked up online to see what I could find out about the papers of Justice Douglas and where they were. And of course, you go to the Supreme Court website and they immediately send you someplace else because it's not the kind of thing that they are collecting and gathering, although they should. But then as you make your way through a number of other websites, I found with great particularity information about the papers of Justice Douglas, which I will share with you. They're at the Library of Congress. There are 1,787 containers of papers, making up 716.8 linear feet. There are a total of 634, roughly, I'm going to give you an approximate now, 650,000 items, one box of classified documents, that sounds very interesting, and 7 oversized boxes. That is transparency. I mean, that gives a member of the public or reporter some sense with a particularity with which it's disclosed there, a confidence that a justice who served on the court for, 45 years, something like that, that those papers are preserved, they're out there for scholars, for journalists who are writing books. And I think when you see something like that in relationship to one justice, it begs the question, why can't we have that for them all? Thanks.
Sonia.
Hi, I'm Sonia West, and I'm really honored to be on this panel today because this is an issue that is really near and dear to my heart. I was very briefly a reporter in my college and post-college days, including an internship at the Reporters Committee, which was amazing, but then decided to go to law school with this hope of defending journalists, which I did for a few years after law school, including in California, trying and usually failing to get cameras into the courts under the California system. So this is an issue. I had the great honor of clerking for Justice Stevens, and so I got to see sort of from behind the scenes what was going on with the court, and also became very interested in what the court coverage was of what I was seeing, and that's when I became a big fan of Dahlia's work because she did such a great job, and became an even bigger fan of Tony's work, who I'd already been following. And I'm now an associate professor at the University of Georgia, where I teach constitutional law and media law, and I write about press issues. And so in terms of what transparency means for me, I'm going to mimic a little bit of what Eric says, that I feel like what transparency means is that the presumption should be a right of access, and that the burden should be on those who oppose access, in this case, the justices, whether or not there's actually a First Amendment right of access in some of these issues, I think there are arguments that there could be. We should nonetheless have sort of the First Amendment presumption that we're going to have public access to this information. And the problems I'm seeing right now, and here I am going to talk about cameras in oral argument, even though I agree we should not get completely focused only on that issue, that there is this wide range of other issues that matter, is that the reasons we're getting, the responses we're getting to the arguments that Clay laid out really well are just not meeting that bar in terms of why we can't have cameras at the oral argument. And the arguments we're hearing from the justices, and we just get this piecemeal when they're asked about it, and they are asked about it all the time when they appear at law schools or at panels, basically fall into three concerns. One is concerns about the participants, that they will engage in showboating and grandstanding. And that just doesn't add up when we look at what's going on in all the other courts that are allowing cameras in. All 50 states have cameras allowed into their courtrooms in some form. Canada's had cameras for more than 20 years. This issue of showboating just doesn't stand up. It also doesn't make sense when you think about what a big deal oral argument at the Supreme Court is. The justices already know that everyone is watching who asks the first question, who sounds a little bit critical in their question. They keep track of who makes the audience laugh. I mean, they know they're on stage here. The advocates know, Willie could probably attest to this. They're not thinking about the audience, they're thinking about those justices and making their points and trying to read the justices. So the idea that showboating would occur, I think, just doesn't add up. Another concern is about the media, what the media would do with camera access, concerns about snippets and sound bites. There's sort of a belief that there's concerns what Jon Stewart and Stephen Colbert would do with these clips. But again, that doesn't add up with the fact that already what we tend to get from the court is snippets and sound bites. We just get it in audio form, or we get it in quotes in the newspaper. We just hear about this question or that question. And so the third area that is actually we're hearing more of these days from the justices, and I find concerning, is that we're hearing from the justices, even Justices Sotomayor and Justice Kagan, who at their confirmation hearings supported cameras in the courtroom, are now starting to say these things. This is a trend, unfortunately, we see. Nominees start out in support, they get on the court, they start to change their mind, which suggests we can't really just wait out this issue. It's not just an age issue. But this is a concern about the public, and that we keep hearing this concern that the public won't understand what they're seeing, that they won't understand oral argument is just a part of the process. They won't understand that the justices have to be harsh on both sides. They might think that someone's getting ganged up on. And I find this to be a very concerning issue because it suggests that more information is actually going to be bad for the public, that the public needs to be shielded from information. And it does seem to have an elitism to it that already those of us who do read the transcripts and listen to the audio or read the reports from the Supreme Court Press Corps, that we're the types that can understand where oral argument falls in the process, but TV would reach a different kind of audience and who wouldn't understand it. So I find this very concerning, and I certainly believe it doesn't meet the bar of, is this argument good enough to go against our presumption that I think we should have of accessibility and openness?
So I want to give you a chance to react to one another, but I want to ask another question. And I think it flicks at one theme that we're hearing today, which is, undergirding this conversation about why the courts are different from the other branches of government is just, I think, this sort of tautological argument that we're different because we're different, and we're just different, and if there's more transparency, we'll stop being different. And yet, almost every variation of the problem of transparency comes down to the idea that, look, justices are different, and that means their papers are treated differently, it means their decisions are treated differently, it means access to them is treated differently. We can't see the texts of their speeches because they're different. And so I wonder if anyone wants to take a crack at this question of, are they different? Are they just different? And if they are, some of these arguments begin to make sense. So Clay, you look like you want to go.
Well, yeah, I think that they are. I think that to an extent they're different because these are the only people inside of government that don't need television in order to get their jobs. I suspect that a member of Congress cannot get elected without television. I suspect the president cannot get elected without television, without stepping in front of a camera, without being in the public, whereas a justice can. And so this idea of, well, I guess, they're confirmation hearings or whatever, but this idea that television or video or transparency is part of their duty becomes sort of difficult because it wasn't part of the job interview process, right? So, I mean, that would be my case for culturally why they are different. I also think that, you have to look at the Supreme Court as a leader, so to speak, for the entire judicial branch, for all of the courts. I mean, the interesting thing is when you look at the Supreme Court's use of the internet and you start comparing it to the lower courts, the Supreme Court's actually doing quite well. It's sort of like, my 1-year-old is doing quite well at speech compared to my cat, but still, he's doing quite well. I think that you're not going to see much change in this field until the Supreme Court changes, because the Supreme Court represents the end of someone's career, all without cameras, all without television, all without transparency. And as such, why would I change now when I've never had to do that in my entire career? I've never found it to be that people at the end of their career are the first to embrace new technology.
Well, the court is not different in any way that would justify a reversal of the presumption of transparency in government.
I just meant culturally.
And also, they do have the nomination hearings, they're not really hearings, but on TV. And they have no problem going on talk shows to hawk their books. But the truth is, the Supreme Court justices are less like judges than any other judge maybe in the world. They're the only judges in the world with life tenure that serve on a nation's highest court. The only ones. Their decisions, as Judge Posner repeatedly says, are essentially political. And the only secrecy they really, I don't want to see their draft opinions. That's fair. I don't want to hear their deliberations with their law clerks. That's fair. But everything they do that's public should be public. And I'll give you an example. This is a small thing, but it cumulatively, it's not a small thing. Justice Scalia was at a conference in Atlanta last Friday. This was a 3-day conference with Posner, Kaczynski, some of the Supreme Court justices of Georgia, and the most famous common law professors in the country. The only person who said you can't tape record, video record my comments is Justice Scalia. And then it turned out that it actually, something happened that doesn't usually happen with Supreme Court justices, and now no one gets to see it. And a public official making a public speech, he ranted about how same-sex sodomy and abortion are not in the Constitution and therefore shouldn't be protected. And he ranted and then got a little bit embarrassed at the end, and no one saw it. If he's going to come to Atlanta and go to the governor's mansion for a reception, which we did, and appear in front of 500 people in a room and give a public speech, it should be recorded. And there's no good reason why we should have had to accede to his request that it not be recorded.
Why did people?
He wouldn't have come otherwise.
Well, just to pick up on these two remarks, it's self-evident that they are different in the sense that other than Justice Kagan, they've come from one cloistered life into another. The route to the priesthood is through the federal appellate courts, and those institutions themselves are bundled up, and so when they get to the Supreme Court, they are don't reflect the range of professions and exposures in public life that other government people would have by the time they got to the high rung.
So you're saying they're different because they have super thin skin, not because they're sort of...
Oh, no, it's because they're culturally... Look, transparency is not a technical issue. Transparency is not really a legal issue. Transparency is a cultural issue. When transparency is a technical issue, or when it is a technical issue, it it fails. It almost always fails. If you look at the president's open government agenda, right? When the president on day one was like, we're going to open up all of this data, and then you go to data.gov and look at like the last time that the data sets got updated, it was like 2009, 2010. And that's because it was very much a technical issue. They made it a technical issue and not a cultural one. And so if an institution isn't ingrained with the culture of technology, then those transparency initiatives will often fail.
Mm-hmm. Willie, I feel like, did you want to respond? Or you lunged like you lunged.
I just couldn't see Eric. But you know, I think if anyone who agrees with Eric that the court is, you know, just another political body and they're doing what they want, they are imposing their will in all of these
Does anybody
cases.
disagree? No, I'm kidding.
Yeah, absolutely. I'm willing to stand up and say that I disagree with you firmly. And I think that because they are not public officials whose job it is to appeal to the public, right? If a member of Congress or the president does something that does not stand the light of public scrutiny, meaning it offends a lot of people, they may well be doing their job wrong. That is not true of judges or justices, right? You know, that is what they are paid to do. And I think that for exactly that reason, you know, the fact that their opinion might be unpopular, who cares? The fact that their private vote, the reasons that they give in conference, which I think, do you think their votes in conference should be public?
No.
Right. So
It's a preliminary vote. It can change.
right. You know, their deliberations are not public. Oral argument is part of their deliberation too, right? It is supposed to be a fleshing out of what is important here.
It's public already, though, with all respect.
Yes, yes, absolutely. That's a separate question. Public in what way? But I think what we need to focus on is who are these people? What jobs do they do? And which parts of it kind of they're just public officials running around giving speeches, selling books, and taking money from the public treasury. You know, and so the fact that they operate a branch of government, they have employees, they take gifts and travel and accept travel and so on. You know, that's all fair game. But when you're talking about the job that they are doing as judges and justices, I think it's different, and I think that equating them with members of Congress and the president is a false,
But
false
I
premise.
would throw in there that the ways that they're different actually argues for open, even in terms of a legal branch and not getting into the political argument. They don't deal with witnesses. They don't deal with juries, things that could raise, some particularly valid issues about those kind of sensitive things. The issues they deal with have the most national importance. So yes, they have life tenure, which almost all other government employees don't have, except some other federal appellate judges. So everything argues that if anybody should have this openness, it would be them, I would think.
They are the only governmental officials in the Western world, anywhere, that are final, leaving aside the constitutional amendment process, which isn't really a check. They are final, they are unreviewable, and they have life tenure. There are no other officials in any Western democracy anywhere that have that job title. If anything, they should have the most transparency because of that, for those reasons.
I guess I'd also, one more sort of valence to this is, how are they different from Canada? Because, I always remember
That's always the question.
hearing, it always comes back to Canada, but I just remember hearing Ruth Bader Ginsburg and Beverly McLaughlin, who was the Chief Justice of the Canadian Supreme Court, talking about this. And someone sort of said, well, this is crazy. Canada's had cameras in the court.
Nobody cares about Canada.
Well, that certainly was Justice Ginsburg's argument. Her argument was sort of like, but that's Canada.
They're not final.
And that's,
They're not final. The Canadian Supreme Court, most of the time, can be overturned by a supermajority vote of the legislature. That's a big difference. These guys, men and women, are final.
So I want to ask a question that I think sweeps in some of the things that you've just talked about, and that is, there are workarounds to all these rules, right? So it's not just the pen camera. That's a new and interesting workaround. But, when Justice Scalia says nobody's going to cover my speech, what happens is someone just tweets it, or, Clarence Thomas came to UVA a couple of years ago, was absolutely off the record. You were sworn to secrecy. Every word of it was published the next day in Politico with mistakes because we don't have a record of it. So there are these, Justice Alito goes to speak week at a dinner, and someone just takes a photo of him, and suddenly, the media has captured it. So it seems to me that more and more, when the court puts up these barriers to transparency, what happens is that what rushes in is less than what they would, what they would afford us if they would just let us in. And so I wonder if anyone sort of has thoughts about, is there some tipping point at which the court says, and so for instance, I'm thinking of the healthcare cases when they were handed down, and for the first couple of minutes, it was wrong. And maybe the court has no obligation to help us get it right. But is there a cost to the court of these workarounds that aren't working?
Last Friday, the Atlanta legal newspaper, the Daily Report, got it wrong. They covered the event Scalia spoke at, and they got it wrong. And now in this case, they actually did it to his benefit, but it could easily have been to his detriment. And it would have been better if someone could say, let's go to the videotape. It would have been a lot better.
I have screenshots of the front pages of Fox News, MSNBC, and CNN on the day of the. And the Fox News said Obamacare struck down, and MSNBC said Supreme Court upholds Obamacare, and CNN said breaking news: Supreme Court issues response. We'll tell you more in a minute. I find that sort of apropos and demonstrative of our media environment. But the interesting thing here is that we're in a more, I think because of the internet and because of technology, we're in a more politicized environment than we've ever been. Take a look at what happened to Shirley Sherrod at the beginning of this administration when, she a 30-second soundbite ends up on the Glenn Beck show and you end up fired for words taken out of context. So I think that there's a level of demonstrable fear, and I think a healthy fear of public scrutiny for the sake of, when I was working at the Sunlight Foundation, part of my issue with sort of transparency as a panacea is not only are you arming the smart lawyers, but you're also arming the Glenn Becks and the Keith Olbermanns of the world to advance things that may not be the truth. Unfortunately, the only real cure is a good transparency. And I look at the political discourse, the activist discourse around things like Citizens United, right? And I wonder how much better our public discourse would be if those deliberations were a bit more public. I mean, I understand that the oral arguments are public, but a bit more public. If the public could see those arguments, and I wonder what harm this lack of transparency is doing to the public, because our discourse has to be distilled into what gets delivered to us through Fox News, MSNBC, and CNN, which seemingly on that day couldn't make up its mind.
Yep.
Dahlia, if it's fair to put the question back to you, with an analogy, maybe not a perfect one, but last summer when disclosures were made, the Department of Justice had subpoenaed AP phone records and seized emails from a Fox News reporter. Holder launched this process to work with the press on trying to figure out what reform needed to happen to media subpoena policy. I would wonder, after some of the glitches in reporting the healthcare decision, why doesn't the Chief Justice wander down the hall at some point, or reporters try to wander up the hall and say,
There's no wandering up the hall.
we need to start talking. This was a monumental decision. The reporting of it was flubbed, and the press needs to work with the court because it's the court's own legitimacy that's at stake. Is that an impossible conversation to have, that you would launch a dialogue the same way that we've launched one with DOJ?
I mean, I think it's a great question. If it's happening, I'm not in that conversation. I'm looking at Tony. He would have been spearheading. But I think that, the answer is in part that the court sort of disaggregates the media's problems from the court's problems. And so, there's this famous story of the press going to Chief Justice Rehnquist and saying, please don't dump 6, 100-page decisions on us and ask us to get it all right. Can you space out decision days so that we can do our jobs and get it right? And the response literally was, why don't you just only cover some of them today? And then you can cover some more tomorrow, as though the news just happens magically, at the caprice of the court. And so I think that the court thinks these are the media's problems. And the court does not feel that there's a cost to, Fox getting it wrong or CNN getting it wrong for 2 minutes.
There is a very substantive problem underlying this procedural transparency issue. And I know there'll be some disagreement about this, but the substantive problem is the justices really feel historically they are special, they are different, they are not political, and it's a temple on a hill. They really feel that way. So they're not going to worry about the press. They're not going to worry about all kinds of things that other governmental officials have to worry about. We can't develop this today, but they're not special. Their opinions are not based on law. They're based more on values and not politics, Republican, Democrat, but their personal life experiences, politics, and they are far less special than they think. And the faster we get more transparency, the more that will become clear.
And to circle back to your beginning about Canada, they do this differently in Canada. And from my understanding anyway, is that, the press corps, someone comes from the court and says, this is what this case is about. This is what happened. This, do you have any questions? This is how we can explain it. And then I think there's even some sort of quarantine for a couple of hours where everyone just reads and figures things out. I'm not sure how I feel about that, but exactly, I think, and they do let them know when big cases are coming so they can be prepared. It's just an idea that there is a different way to do it. And I think what we're hearing here is this idea that from the political branches, there's sort of an understanding, a love-hate relationship with the press, that the press both hurts and helps what it is they're trying to do. And with the court, it's really more just the either apathy/hate, and this idea that the press could really help them in terms of, if they worked with this in terms of public understanding of what it is they're trying to do is what's missing, and it's a shame that they can't get more into that mind frame.
Willie, do you want to?
Oh, I'm curious, when they let some people into the cloister and give them an advanced peek at the opinions, is that members of the institutional press? Does it include bloggers? Does it include, interested members of the public who might want to talk about it on their own radio show?
I wish we had that problem. That would be a great problem to have.
No,
I actually don't know the answer to that. Of course, we already have a Supreme Court that gives out press credentials, so it's making those kind of decisions on, questionable grounds.
Right, it is giving out reserved seats to members of the institutional press, right, and denying them, say, to people who might have a blog. But everybody gets the decisions at the exact same time, right?
Yeah, I'm not advocating we do things exactly like Canada, because I actually think the sort of 2-hour quarantine or whatever it is a little questionable constitutionally. Yeah.
SCOTUS blog doesn't have a press credential right now in the Supreme Court. That if any other branch of government was making a decision so unbelievably stupid, it would be on the front page. I mean, SCOTUS blog is where we get our information about the Supreme Court, and they're denied a seat at the table. That is crazy. Now, there is an argument that Tom Goldstein, who owns SCOTUS blog and argues cases, there may be some conflict. That is not for the Supreme Court to decide. SCOTUS blog is our main source, other than Dahlia's and Tony's amazing articles, about the Supreme Court, and they don't even get a seat in the room.
Respectfully, isn't that kind of a circular argument? SCOTUS blog has covered the court and made itself essential, so the court has to let them in?
Yes, of course. It's the press. Yes.
Sure. No, I certainly agree with you that they're the press, but what form of access is it that you, what are you focused on? It's not a hostile question. What access for SCOTUS blog is it that you're focused on?
I will tell you. So Adam Liptak, who I think is great and fantastic and is a Supreme Court reporter for the New York Times, gets to hear the oral arguments, gets to hear the decision announcements, see Justice Alito doing this as Justice, I think it was Kagan was reading a decision, I forget. Ginsburg was reading a decision. He gets to see that firsthand, in person, and he was talking about this last Friday, in that it's hard for him because he'd rather be writing, but he wants to be in the room because that's the most important thing over time. SCOTUS blog's Amy Howe, is not in the room, and she doesn't have that benefit of seeing it firsthand with all the emotions attached. And at this moment in time, with all due respect to Adam and the New York Times, I think SCOTUS blog deserves a seat in that room more than the New York Times because they're trying to live blog it.
But isn't Lyle in the room? Lyle's in the room.
Well, but only because he has an independent press credential, not as a representative of SCOTUS blog.
So one thing that I like to tell people is that when we had to decide when the healthcare cases, sorry to keep perseverating on the healthcare cases, it was very traumatizing for the press. So I'm not over it yet, but I'm working through it with your help. But one of the things that was super, I think, emblematic of what Eric is describing is you literally had to make a choice between either being in chamber watching, this historic hand down, right? Watching John Roberts read his opinion, watching Ginsburg, read, and then knowing that when you were finally allowed to leave 19 hours later, because they were reading, that it was over, right? It had been tweeted, it had been discussed. Wolf Blitzer had been talking about it for an hour and a half. For purposes of my editor, it was over, but I chose to be there. But the other choice was to be in a room where you could hear it, but you couldn't, if you left, you were stuck, so you could hear it but not leave. Or you could be in a room where you could neither see nor hear, but you could write. So it was like the three monkeys. It was hear no evil, see no evil. Like, you had to choose which monkey you wanted to be. And it seems to me that in 2012, was it 2012? We need to be like upping the ante on the monkeys. Like, that's not how to cover, a major historic opinion. And, I think it loops back a little bit to Bruce's question, which is, does it affect the court that we didn't, maybe it doesn't. Maybe the court didn't care.
I'll tell you, there's two ways to sort of look at this in terms of transparency. It goes back to my opening argument. Maybe the court didn't care. Maybe the court shouldn't care. But the video could be released a year later or 5 years later, and it would still have an impact, right? And it would still be profoundly useful to the legal profession, to law students, to the whatever the 50,000 law students that weren't allowed in the room. And I think that we have to start thinking about transparency as being a bit larger than helping reporters. And it being about reflecting the dignity and majesty of the court and the importance of the law, which is, the other part of this argument is that the law itself is completely locked up from the public, and the only thing that's sort of more morally offensive to me than the judges being locked up to the public is that I have to pay, as a citizen of the state of Georgia, I have to pay a company called LexisNexis $800 to get access to the official code of Georgia. That is gross. That we've privatized that is that our courts, our courts are basically paying Westlaw hundreds of millions of dollars for access to its own records. Is preposterous. I mean, this is a thing that is, I think, hampering the legal profession. It is a thing that is hampering our own history, and I think it's something that does not reflect the values of either the Constitution or the United States.
Thank you for saying that. That's a useful frame. So we've got some questions, and you're encouraged to write questions and hand them to a person who's going to collect them. But so I'm going to ask the first question that I've got. Since asking nicely appears to be an ineffective strategy so far, how do you or your organizations propose to make actual change and increase transparency?
In 1802, I think it was, Congress shut down the Supreme Court for a year for really bad reasons. But they did do it. They turned the candles off, and the court did it. I think Congress will probably never do this. I think it'll be fully constitutional for the Congress, which funds the Supreme Court, to give the court a choice.
Just convince the cable industry they'll make money off.
Either televise your oral arguments and decision announcements, or do with no heat, no air conditioning, no lights, and fund yourself. I think that's a fully constitutional use of Congress's power, and I think they should do it.
Does anyone
All right,
have
we're done.
a less radical notion that they'd like to float?
Well, I think the issue of the credentialing of SCOTUS blog has been kicking around for a while, and I think it would be interesting to see that taken to another level, to kind of force the court to examine its own practices in a public way, transparent way. And and I think that we're part of this effort that we're engaged in today is part of an ongoing initiative to focus public attention on these issues and to hope that the people in the building who are there to protect the long-term reputation of the court. I mean, we just touched on it a few minutes ago. How do you get them to focus on the fact that they need to protect their own institutional legitimacy, and that essential to that is this kind of transparency initiative or agenda. I do feel that when you look back at Richmond newspapers and those cases that were so important to the media, that at least the court and the press were kind of in sync back then. And what seems so discouraging today when you think about trying to get reform by bringing lawsuits is that we're so out of sync. The press and the court are so completely out of sync today. And there was something special about that moment in the 60s and 70s where they were really working together, and they're not today. And I think it does make me think that the kind of strategy that we used in those decades probably will not be the most effective one today.
So,
The litigation strategy, in other words, yeah.
I think the cameras in the courtroom thing is sort of a done deal. I think 10, 20 years out, I'll have a small camera in my eyeglasses or something like that. That will be, the pen camera is just sort of the start of it. But, what's the Supreme Court going to do? Ban people from wearing glasses in the Supreme Court?
Yes, with cameras in them.
But they'll be undetectable. I don't think that. I think that cameras will be within the next 20 years undetectable.
They're taking notes right now.
The pen camera is like the tip of the iceberg, and that technology is going to solve that problem.
Right now, if you walk into the D.C. federal courthouse, you have to, if you're not, I think they make an exception for lawyers actually showing up for a case, but they will make you surrender your phone.
Yeah,
because
sure.
it might have a camera
Right,
in it. And
right.
5 years from now, you may be surrendering your eyeglasses.
I suspect that if you remove removing my ability to make phone calls is significantly different than removing my ability to see.
yeah.
Right.
Yeah.
The other stuff though, personal financial disclosures and stuff like that. Who knows how that will happen, or if it can and ever will.
So let me segue to the next question, because we've got heaps of them. Who gets, this is just an informational question, who gets to decide on the changes in the policies about transparency? Are these all decisions taken by the Chief Justice? Does the court vote? Is the staff voting? How does
We don't know. That's how lack of transparent it is.
Right.
We don't even know.
Right.
And it's questionable, it's really unknown whether if Congress passed a law, whether or not that would apply to the court, whether they could make them do that. So we really don't know how.
The
the
closest
process would be.
indication that we got was when they closed the doors. When they closed the front doors, they published a dissent by Justice Breyer saying we should not have done this. We should still allow people to walk in the front door of our building.
Yeah.
Let's be clear, though. Congress could do this. If the political will was there, they have the money. They could do it. There's nothing the justice could do.
It's Justice
declare it
Scalia who's,
unconstitutional.
I'm sorry, that was interesting. It's the Chief Justice who's making the decision about audio policy, and we know that, right? That the Chief was making the decisions about which cases were going to be audio, same-day audio. I think it was anyway, I think it was clear.
That's my understanding, right?
Yeah.
And it was a case by case.
Right.
Today
Right.
we'll release
Yeah.
this one, but the other ones you'll have to wait till Friday.
Right.
But when they decided to start releasing audio on Fridays instead of at the end of the term,
Yeah.
I don't know if that was.
I don't know.
Justice Chief alone.
It's a
Dahlia,
problem.
When Justice Douglas got extremely sick and had a stroke, the justices took, Americans don't know this, a secret vote. And they decided that they would not decide any case where Justice Douglas's vote would matter. Can you imagine that? The 8 justices secretly decided that they would not decide any case where Justice Douglas's vote would matter. The only reason we know that today is because Justice White was so offended that he wrote a public letter about it. Had he not done that, we would never know. And I mention that only because that's how they view themselves. They view themselves as having no obligation, for example, to tell the American people that Justice Douglas was so sick that he couldn't decide a case, and that they would then decide arbitrarily which cases his vote might matter and not decide them.
So that also goes to the Justice Scalia, je recuse, when he, refused to recuse himself in the Duckgate oral argument, and he kind of did America this courtesy of writing us a long letter explaining why he didn't think he had to recuse, and I came away saying, why don't they all explain their recusal decisions? Because, oh my God, the legitimacy not just of them as individuals, but of the court can't help but be, raised in the eyes of everyone to just see this thinking, this behind the scenes thinking. It's incredibly material when they recuse and why. And the idea that we kind of know today why Justice Scalia sometimes chooses not to recuse himself is not a standard, right?
Don't get me started on Kagan and the healthcare case.
Okay,
We'll be here all
okay.
day.
Are the Eric, you're not allowed to answer this one. Are the justices fundamentally afraid we're going to learn that they're just not as neutral as they say they are when they're deciding cases? Is that the fear? Anyone? Eric, you can answer.
Okay. Yes, unequivocally, yes. They spend, I'll do it real fast. They spend so much time and energy in their written opinions, which is their argument for why they don't have to be transparent, because everything comes out in the written opinion, hiding the reasons why they do what they do. Because in almost every written opinion, you will see text, history, and precedent. And they'll say, this is the text, this is the history, this is the precedent, A, B, C adds up to D, we vote.
Where do you want to take the cameras that will find the hidden
No,
part?
I'm just suggesting the answer to the lack of transparency can't be the written opinions is what we share with the public because they're dishonest written opinions. The real reasons why they decide the way they do is not in the text, history, and precedent. That's important, but it's in a whole different set of values and life experiences, which is why Scalia and Ginsburg, who are good friends and go to the opera together and are smart, brilliant lawyers, disagree on virtually every contested issue of constitutional law that gets to the Supreme Court. It's not because they have different skills, it's because they have different values, and they would never admit that in public. And that's crazy.
I point out that transparency won't solve that problem.
No, I know.
Just because you turn the lights on in a roach-filled apartment, it doesn't kill the roaches.
I didn't use that phrase. That wasn't my phrase. Let me be clear.
But you see what I'm saying? Like sunlight, it turns out that sunlight isn't a particularly good disinfectant. Alcohol is much better. You can't. When you turn the lights on, when you shine the lights at things, the shadiness just moves to the corners. The roaches crawl into the
Disagree
refrigerator.
because Scalia's a little bit bullish attitude does come out at oral arguments. I don't think he would change that. And knowing his character, which is a little bit of a bully with all due respect, is important to the American people. We should know that he is a little bit of a bully. We should know better than we do that Justice Thomas never speaks.
Yeah, but he's not going to so we'll know that he's a bully, but as you said to begin with, it's final. He's there. He's a lifer. So it's not going to change anything.
I think it's true, too, that just general fear is part of this. Justice Breyer's even said this, just sort of fear of the unknown. Justice O'Connor said this, too. We just don't know what's going to happen, and we've just done it this way for a long time, so let's just not change anything.
It has to be cultural.
And a sense of, this is an institution we need to protect, and we don't want to go making changes. And, a fear of loss of privacy is clearly very important to Justices Alito and others, and loss of anonymity. And so there's certainly, I think, just overall fear that is part of a lot of these.
Well, and they have to look at the deeply unpopular nature of the other branches and think that maybe ignorance of what they do is better.
What is their approval rating?
Right.
Comparably.
Yeah.
Higher.
I think it's higher, yeah. And they messed.
But that's what's so sad, because anybody who's been to oral arguments, it's
majestic.
It's terrific, right? It's majestic.
Right.
The questions are so smart. Everyone is prepared. The arguments are great. It's a terrific experience,
And if it would remain exactly the same with cameras, that everyone assumes that would be great, right? But that's the if, right? That's what worries them, that it wouldn't be exactly the same. And I know everyone else on this panel is absolutely convinced that they would be exactly the same, if not better.
No, I don't know. No, wait a minute.
The same if the videos
That's
were
not
released
true.
a year later.
That's not true. I don't know what would happen. I'm not smart enough to know. The question is, where's the presumption? And the presumption should be an openness, and only if there's a really good reason should it be secret. And since we don't know, I think if it was a court of law, the burden of proof would be on the justices, and you can't say, I don't know. That's not a good reason. And we don't know.
I think Clay's point is a very important one, that we're having a fight about, does it have to be right now, today, right? And your point is that if they videotape them for history and release them later, that would have its own value. There, the fear is that, the Reporters Committee will never give up, right? If the videotape exists, they will want it, and they will want it not on Friday, they will want it today, and it's certainly not in 10 years or 50 years, just like they are with the justices' papers. But I agree with you. The video would have tremendous historical value, But the question is whether you could hive that off.
I'd also point out that, prop comedy in the United States Congress has really taken off since.
Well, you can make a rule for the Supreme Court bar that props would be prohibited.
I taught Brown last week in class. I taught Brown to a generation of students. There's a hotel 2 blocks from my law school that didn't take African Americans in 1965. And then, if they could have seen the oral argument in Brown, it just would have made a so much more powerful impression.
Yeah.
The fact that we can't do that is almost criminal.
Or Bush v. Gore, or the
Right.
healthcare cases. I mean, yeah.
You can listen to Bush v. Gore.
You can listen to Bush v. Gore,
conversations.
right.
You can't see what Ted Olson's face looked like.
Right.
You know.
And am I misremembering, I think, Sonia, you know the answer to this, that the British Supreme Court in the UK have the cameras trained not on the justices, but on the advocates.
On the advocates.
And the idea is that they want students to be able to learn oral advocacy, and so they can watch that. So it is, there are sort of hybrids where you preserve, query whether you want that. Bruce doesn't want that. But, at least you can say there's this education purpose and there's this, somewhat historic purpose being met. And students can learn and watch and the greatness of what happened and still protect judicial privacy. So there's something in the middle.
Can I ask, even if you're against cameras at the oral arguments, and I really can't fathom anyone being against that, how can you possibly be against cameras at the decision announcements? What possible reason would there be to not have cameras? Had there been cameras the day DOMA was struck down, millions and millions of Americans would have had a shared citizen moment of unbelievable historical and present-day significance. And what possible downside could there be to hearing Justice Kennedy announce this historic decision? I mean, how could there possibly be a downside to that?
I'm going to read, unless...
I'll just say, I think one of their arguments would be that the opinion announcements are actually not the opinion themselves. They're not signed off by all the justices in the majority. The authoring justice writes it. Sometimes the other justices are like, huh, what? That's what we agreed to. There's sort of that legitimacy. I again agree with you. I think
Lots
it should
of
be there.
interns would start gaining weight because they wouldn't have to run. Obesity is a problem in America.
But we still have the snippets and the sound bites.
Here's another I'm just trying to get through as many as I can, but this is interesting. Does true transparency now require that justices' records must be available online?
Yes.
Isn't it too limiting in an electronic era to have access to some dusty boxes in a library somewhere?
The answer to that is
Yeah,
yes.
it's a good point. When I did my little adventure online to try to figure out where Justice Douglas papers were, you saw how few of these archival materials are actually available online. A very small percentage. And the rest that are available, and of course there are many, many, many that aren't, but the rest that are available, it's true, you've got to go to a research institution somewhere.
That's just,
get
that's a
access.
money issue, right? Because, I think Lee Epstein has gone and, had some intern photocopy and digitize, put a digital camera on a little tripod and took pictures of the pool memos, the law clerk's memoranda to the, up to 8 of the justices who participate in deciding whether to grant a particular cert petition or not. She's gone through the Blackmun papers and had someone take pictures of every page of every pool memo, and they're on a website somewhere. The Library of Congress didn't do that for us, but now they're there. It's a great resource.
Yeah,
It's just a question of who does it.
Right.
I think 50 years from now, Supreme Court justices working with paper is going to be absurd just because the people as they work through who 50 years from now wouldn't look at sort of a keyboard as their first method of creating text?
5 years from now, 50 years from now.
I'm playing safe.
You have kids?
I'm playing safe.
And that is being lost. I think that, to the extent that the justices are emailing with their law clerks and saying that I'm not so sure about the quote on page 7. What if we said blah, 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 blah? That is, I'm confident, is going to be lost to history. That they may save the paper drafts that get circulated. And that's one reason to be glad that they still use paper and messengers and photocopiers, because that at least will be saved.
On the other side is yes and no. The digital records are much easier to preserve, right?
Well, I'm not saying they shouldn't
capture,
preserve
so-
them. I'm just saying that I suspect
Yeah,
that they
they
don't.
won't,
So
right.
be glad that there will be something left for history.
I'm sure they all use.
And nobody is arguing we have a right to the discussions between justices and their law clerks during the deliberation process. I don't think anybody's arguing that. I'm certainly not.
I would argue 100 years later, perhaps.
I wouldn't. I think
No.
that has to be confidential.
I think we have time for just this last question. So a few questions I didn't get to, and I apologize. What, if any, problems or unintended consequences have high courts in other countries, or I would add, state courts, or what problem or unintended consequences have other courts had after allowing cameras in the court? So I think this is the Lance Ito question.
Well, a Supreme Court justice in Ohio has been doing a whirlwind tour because they have cameras there. I forget her name, I apologize.
Maureen
And-
O'Connor.
O'Connor, yeah.
The other Justice O'Connor. Her answer is, I've really thought about this. I've canvassed other judges. More than half the states do it. Zero. That's her answer. Nothing bad has come out of it. They can't find any evidence of any harm coming out of. Now, I'm sure that's an overstatement, but that's her position.
Name a case decided by the Supreme Court of Ohio. Name one.
Why does that matter?
Because the amount of attention focused on yes, they're all broadcast on the Ohio News Network. The amount of attention is not comparable. It's not a comparable
If we were in Ohio,
situation.
the answer may be different.
But do you really think that's going to affect the behavior of judges or lawyers in front of the Supreme Court?
Lawyers.
You do?
Certainly. Have you ever been to an oral argument at which an elected state attorney general takes the lectern and argues for the state?
Well, but that happens today. If you're the Attorney
Yes.
General of Georgia, you're going to be very careful what you say in front of the Supreme Court. I don't know if a camera is going to make a difference. But anyway, in our society, it's too late. I mean, it's just too late. It's a public hearing. Some people get to go in. We're done. At that point, any other institution of government would have to televise its proceedings if someone's willing to pay for it.
Ronald Goldfarb, I think is his name, wrote a book where he studied all of these experiences with cameras in the courtroom all over, and he said it just follows the exact same pattern, sort of, skepticism and concern at the beginning till general acceptance, and then usually like enthusiasm to the end. It sort of follows the same arc as people get used to it and they realize it's not that issue. Iowa's had cameras in their courts for more than 30 years, and their chief justice has come around, testified at Congress saying, just no problems. It's actually been great. We put it up online, and people have access to it. So, as far as this fear of the unknown with the justices, what other way can we test it out other than in these other similar appellate courts, state courts? Canada, again, has had good experiences. Other than running the experiment, in the Supreme Court, that's our best guess. And the evidence there is just extremely strongly in favor of it, not of it working smoothly, not having problems.
And it can't be the case that only unimportant things get, right? Only Ohio gets, because we can't name the case. That was the court's argument, right? When they decided to pull the TV cameras out of the Prop 8. When the district court was ready to roll, and when the court issues its per curiam, the argument is, no, this is too important. People care too much to have cameras. And so what is that argument? That only unimportant things should be televised? That can't be right.
And Dolly, that decision, that procedural transparency decision had a hugely substantive effect. Because if people could have watched that trial, they would have seen Ted Olson and David Boies, Ted Olson, famed conservative, destroy any plausible public policy arguments against same-sex marriage other than religious, faith-based ones. And that would have had an even greater effect on America than the argument already had. And so that procedural decision was hugely important.
It is interesting, though, that when Judge Walker handed down his decision in that case, now, I may be wrong. Certainly this is true of the Ninth Circuit decision affirming that. Maybe I have my facts wrong on Judge Walker, but I think everyone got an email, right? Ping! Here's the decision. Everyone opens it. You read a PDF. The Supreme Court, they all put their robes on and they all take the bench and they all go up there and they read a summary of their opinion, because that is an exercise in transparency. They don't have to do that. No other court does that. I understand that you think that they ought to televise that because it would be meaningful and historically significant to hear it. But it is important to remember that that's something unique that the Supreme Court does. And, lots of other courts don't do it, and if Congress decided to pull their funding, they might well say, "Hey, we won't do that anymore."
And of course,
I'm going to stop us there because it's time, and I want to say, you guys should write articles about this. But I really, really want to thank Gabe Roth and his team for putting this together. I want to thank NYU. I want to thank Bruce Brown, Eric Siegel, Sonia West, Clay Johnson, and Willie J., and all of you for being here. This is a terrifically important issue, and really this has been one of the best panels on this issue I've ever seen.
I agree.
Thank you.
Thanks.